Welcome all to today's class on the concept of judicial review, a comparative study among US, UK, Canada, Australia, France and Switzerland. This is for Administrative Law Dr. K. Sangeeta. Judicial review is a process under which executive or legislative actions are subjected to review by the judiciary. A court with the authority for judicial review may invalidate a law or the governmental action that are incompatible with the higher authority. Judicial review is one of the check and balance in separation of power. The doctrine varies between jurisdictions, so the procedure and the scope of judicial review may differ between and within countries. Judicial review, as formulated by the Chief Justice Marshall of the American Supreme Court, had a number of objectives. First, to uphold the principle of supremacy of the Constitution, to maintain federal equilibrium, balance between the center and the state, to protect the fundamental rights of the citizen. Judicial review should be understood in the context of two distinct legal systems, civil law and common law, and also by two distinct theories of democracy, doctrines of legislative supremacy and separation of powers for much better study and analysis for the reason which follows. According to Alexander Hamilton, the interpretation of the law is proper and peculiar province of the court. The Constitution is in fact and must be regarded as the judges as the fundamental law. It is therefore belonging to them to ascertain its meaning and the meaning of the act passed by the legislature. The concept of judicial review was developed by Justice Marshall, the American Supreme Court, in the famous case Marbury vs. Madison case in 1803. It was laid down that judiciary has the power to examine the law made by the legislature. It was also declared that in any such law it is found to be in violation of the Constitution, then such a law would be declared by the court as ultra vires of the Constitution. While doing so, the Supreme Court referred to Article 6, Section 2 of the Constitution. This Constitution and the laws of United States, which shall be made in pursuance thereof, and the treaties made, which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereof. Anything in the Constitution or the laws of any state to the contrary notwithstanding. The US Constitution does not mention judicial review. In 1789, the Congress of the United States passed the Judiciary Act, which gave federal courts the power of judicial review over the act of the state government. The power was used for the first time by the US Supreme Court in Hilton vs. Virginia. Till today, nearly 100 congressional statutes have been declared unconstitutional by the Supreme Court. After judicial review is conducted by the Supreme Court, it can give three types of decision. First, the law is unconstitutional. The law is constitutional and fair. That any part or some part of the law are unconstitutional. On the basis of the Fifth Amendment of the Constitution, the scope of judicial review has become very vast. It lays down the government cannot deprive anyone the life, liberty and property without due process of law, which is fair trial for meting out the ends of justice. The court does not conduct judicial review over political issues. The court has to ascertain reasons for declaring a law unconstitutional. It cannot initiate the process of its own. The law declared invalid ceases to operate for the future. The work already done on its basis continues to be valid. The court has to demonstrate clearly the unconstitutionality of the law. When one talks of judicial review in the context of constitutional law, one would think that necessary ingredient is a written constitution. However, this does not mean to say that the concept is not relevant to countries having unwritten constitution. In United Kingdom, judicial review deals with public law, wherein a judges reviews the decision or the action of a public body and its lawfulness. Till recently, the courts were meant to enforce the will of the parliament. Thus, they were not allowed to review the act of the parliament itself. Therefore, judicial review was not present in respect of primary legislations, but only to the subordinate or delegated legislations. However, this position has been changing from time to time, not just due to the act of the parliament itself, but also because of the active role of the judiciary, which has started taking in this respect as well. We will see the rest in the next slide.